Legal Ethics, Canon 6, CPRA Canon 6, Section 21, Preliminary Conference Order, Position Papers. Within 10 calendar days from receipt of the preliminary conference brief, the investigating commissioner shall issue a preliminary conference order on the basis of such brief submitted by the parties and counsels, summarizing the stipulated facts, issues, and mark exhibit. The investigating commissioner shall further direct the parties to submit their verified position papers within a non-extendable period of 10 calendar days from receipt of the preliminary conference order. Section 22. Clarificatory hearing. Within 10 calendar days from receipt of the last position paper, the investigating commissioner shall determine whether there is a need to conduct a hearing to clarify factual issues and confront witnesses. If deemed necessary, the investigating commissioner shall set the hearing within 15 calendar days from such determination and identify the factual issues to be made subject of the hearing. The investigating commissioner may subpoena any witness to appear at the hearing to answer clarificatory questions. Thereafter, the investigating commissioner may allow the parties to confront the witnesses and propound their own clarificatory questions on the factual issues identified by the investigating commissioner. The clarificatory hearing may be done in person or through video conferencing. If it is conducted in person, the clarificatory hearing shall be done at the most convenient venue for the parties. The clarificatory hearing shall be terminated within 30 calendar days from its commencement. Section 23. Minutes of proceedings. The proceedings before the IBP shall be recorded. Section 24. Non-appearance of parties. Non-appearance at the clarificatory hearing shall be deemed a waiver of the right to participate therein. Section 25. Issuance of report and recommendation by the investigating commissioner. If there is no clarificatory hearing, the investigating commissioner shall render a report and recommendation and submit the same to the IBP Board of Governors within an extendable period of 60 calendar days from receipt of the last position paper or lapse of the period given. In case the investigating commissioner sets a clarificatory hearing, the report and recommendation shall be rendered and submitted to the IBP Board of Governors within a non-extendable period of 30 calendar days from the termination of the hearing. The report and recommendation shall be accompanied by the duly certified transcript of stenographic notes or in lieu thereof, the audio recording, if any, or the investigating commissioner's personal notes duly signed, which should be attached to the records together with the evidence presented during the investigation. The submission of the report need not await the transcription of the stenographic notes, it being sufficient that the report reproduce substantially from the investigating commissioner's personal notes any relevant and pertinent testimony. If the hearing is conducted through video conferencing, the proceedings shall be recorded by the investigating commissioner. It shall form part of the records of the case, appending thereto relevant electronic documents taken up or issued during the hearing. Section 26. Submission of resolution by the Board of Governors. The IBP Board of Governors shall have a non-extendable period of 90 calendar days from receipt of the report and recommendation of the investigating commissioner, within which to submit to the Supreme Court its resolution adopting, modifying, or disapproving such report and recommendation. Section 27. Depositions. Depositions may be taken in accordance with the rules of civil procedure with leave of the investigating commissioner. Section 28. Filing and service. The filing and the service of papers or notices required by this canon shall be made with the commission or upon the parties personally by registered mail, accredited courier, electronic mail or other electronic means, or as provided for in international conventions to which the Philippines is a party. For this purpose, the office address and the electronic mail address supplied by the lawyer to the IBP. For this purpose, the office address and the electronic mail address supplied by the lawyer to the IBP shall be the official addresses to which all notices, orders, and processes shall be served. Proof of filing and service shall be submitted in accordance with the rules on civil procedure as amended. Section 29. Substantial defects. Motion to reopen. Any substantial defect in the complaint, notice, answer, or in the proceeding or the investigating commissioner's report, which may result in the miscarriage of justice, may be raised as an error before the Supreme Court, unless the defect results in the deprivation of the right to due process. In case of the latter, the matter may be brought before the IBP Board of Governors by way of a motion to reopen within 60 calendar days from knowledge. Section 30. Proceedings initiated before the Supreme Court. In proceedings initiated by the Supreme Court or proceedings commenced by complaint filed with the Supreme Court, the Supreme Court may refer the case for investigation, report, and recommendation to the Office of the Bar Confidant or the IBP or other fact-finding body that is designated or created by the Supreme Court for such purpose. Cases referred to the Office of the Bar Confidant or other fact-finding body or the IBP shall proceed in the same manner provided in Section 5 to 29 of this canon. In any event, the report and recommendation of the investigation shall be reviewed directly by the Supreme Court, which shall take such necessary action on the report and recommendation as may be warranted. Section 31. Preventive suspension. After receipt of the respondent's answer or lapse of the period therefore, the Supreme Court, on its own initiative or upon the recommendation of the IBP Board of Governors, the Office of the Bar Confidant, or the fact-finding body referred to in Section 30, may suspend a lawyer from the practice of law during the pendency of the investigations for a period not exceeding 180 days. 180 calendar days or until such suspension is lifted by the Supreme Court in order to prevent interference with or obstruction of the investigation, tampering, concealment, or destruction of evidence, intimidating or exerting undue influence on any witness. Section 32. Quantum and burden of proof. In administrative disciplinary cases, the complainant has the burden of proof to establish with substantial evidence the allegations against the respondent. Substantial evidence is that amount of relevant evidence which reasonable mind might accept as adequate to justify a conclusion. Section 33. Serious offenses. Serious offenses include a gross misconduct or any inexcusable, shameful, or flagrant unlawful conduct. B. Serious dishonesty, fraud, or deceit, including falsification of documents and making untruthful statements. C. Bribery or corruption. D. Gross negligence in the performance of duty or conduct that is reckless and inexcusable, which results in the client being deprived of his or her day in court. E. Conviction of a crime involving moral turpitude. F. Grossly immoral conduct or an act that is so corrupt or false as to constitute a criminal act or so immoral as to be reprehensible to a high degree. G. Misappropriating a client's fund or properties. H. Gross ignorance of the law or procedure or the disregard of basic rules and settled jurisprudence when either is attended by bad faith, malice, or corrupt motive. I. Grossly undignified conduct prejudicial to the administration of justice. J. Sexual abuse. K. Gender-based sexual harassment or discrimination. L. Open defiance to any order of the court, tribunal, or other government agency. M. Threat of physical or economic harm amounting to a crime directed at a fellow lawyer, the latter's client or principal, a witness, or any official or employee of a court, tribunal, or other government agency. N. Willful and deliberate forum shopping through gross negligence. O. Intentional violation of the rule on privileged communication. P. Violation of the notarial rules except reportorial requirements when attended by bad faith. Q. Intentional violation of the conflict of interest rules. R. Influence, peddling, or using one's relationship to obtain a favorable action on or outcome in any pending matter or proceeding, directly or indirectly, with or without monetary consideration from any officer of a court, tribunal, or other government agency. S. Unlawful discrimination under Canon 5. And T. Sale, distribution, possession, and or use of illegal drugs or substance. Section 34. Less serious offenses. Less serious offenses include A. Simple misconduct or such misconduct without manifest elements of corruption, clear intent to violate the law, or flagrant disregard of established rules. B. Simple negligence in the performance of duty or such negligence which does not result in depriving the client of his or her day in court. C. Violation of Supreme Court rules and issuances in relation to bar matters and administrative disciplinary proceedings, including willful and deliberate disobedience of the orders of the Supreme Court and the IBP. D. Simple dishonesty. E. Other violations of the conflict of interest rules. F. Prohibited borrowing of money from the client. G. Prohibited lending of money. H. Other unlawful threats. I. Instituting frivolous or baseless actions on the basis of final decision or order dismissing such action for being frivolous or baseless. J. Violation of the sub judice rule. K. Deliberate failure or refusal to pay just debts. L. Termination of legal services absent good cause and written notice. M. Use of intemperate or offensive language before any court, tribunal, or other government agency. N. Unjustifiable failure or refusal to render an accounting of the funds or properties of a client. O. Unauthorized division of fees with a non-lawyer. And P. Other violations of reportorial requirements. Section 35. Light offenses. Light offenses include A. violation of IBP rules and issuance governing membership in the IBP. B. Use of vulgar or offensive language in personal dealings. C. Fraternizing with the official or employees of a court, tribunal, or other government agency where the respondent has a pending case or cases to such a degree and frequency as would give the appearance of power or influence over them, or which tends to create an impression of impropriety. D. Filing of frivolous motions for inhibitions. E. Failure to promptly call upon client to rectify a fraudulent act, or F. Other similar or analogous infractions of the CPRA. Section 36. Assisting in the commission of an offense and assisting in the commissions of an offense. Any lawyer who shall knowingly assist another lawyer in the commission of any serious, less serious, or light offense punished by the CPRA may also be held liable. 37. Sanction. A. If the respondent is found guilty of a serious offense, any of the following sanctions or combination thereof shall be imposed. 1. Disbarment. 2. Suspension from the practice of law for a period exceeding 6 months. 3. Revocation of notarial commission and disqualification as a notary public for not less than 2 years. Or 4. A fine exceeding 100,000 pesos. B. If the respondent is found guilty of a less serious offense, any of the following sanctions or a combination thereof shall be imposed. 1. Suspension from the practice of law for a period within the range of 1 month to 6 months, or revocation of notarial commission and disqualification as a notary public for less than 2 years. 2. A fine within the range of 35,000 to 100,000 pesos. C. If the respondent is found guilty of a light offense, any of the following sanctions shall be imposed. 1. A fine within the range of 1,000 to 35,000 pesos. 2. Censure. Or 3. Reprimand. In addition to the above sanctions in paragraph C, the respondent may also be required to do community service or service in the IBP legal aid program. In all instances, when the offense involves money or property owed, which is intrinsically linked to the lawyer-client relationship, the respondent shall be ordered to return the same. Section 38. Modifying circumstances. In determining the appropriate penalty to be imposed, the court may, in its discretion, appreciate the following mitigating and aggravating circumstances. A. Mitigating circumstances. First offense, except in charges of gross misconduct, bribery or corruption, gross immoral conduct, misappropriating a client funds or property, sexual abuse, and sale, distribution, possession, and or use of illegal drugs or substance. 2. Absence of bad faith or malice. 3. Return of the amounts owed. 4. Expression of remorse. 5. Reconciliation with the complainant. 6. Rectification of wrongdoing. 7. Act or omission did not prejudice the client. 8. Age. 9. Number of years in the practice of law. 10. Humanitarian considerations. And 11. Other analogous circumstances. B. Aggravating circumstances. 1. Finding a previous administrative liability where a penalty is imposed regardless of nature or gravity. 2. Age. 3. Number of years in the practice of law. 4. Employment of fraudulent means to conceal the offense. 5. Respondent's act or omission was tainted with bad faith or malice, except when it is an element of the offense. 6. Lack of remorse. 7. Failure to comply with the orders of the court and the IBP in relation to an administrative case. And 8. Other analogous circumstances. Section 39. Manner of imposition. If one or more aggravating circumstances and no mitigating circumstances are present, the Supreme Court may impose the penalties of suspension or fine for a period or amount not exceeding double of the maximum prescribed under this rule. The Supreme Court may, in its discretion, impose the penalty of disbarment depending on the number and gravity of the aggravating circumstances. If one or more mitigating circumstances and no aggravating circumstances are present, the Supreme Court may impose the penalties of suspension or fine for a period or amount not less than half of the minimum prescribed under the CPRA. If there are both aggravating and mitigating circumstances present, the Supreme Court may offset each other. Section 40. Penalty for multiple offenses. If the respondent is found liable for more than one offense arising from separate acts or omissions in a single administrative proceeding, the court shall impose separate penalties for each offense. Should the aggregate of the imposed penalties exceed 5 years of suspension from the practice of law or 1 million in fines, the respondent may, in the discretion of the Supreme Court, be meted with the penalty of disbarment. If a single act or omission gives rise to more than one offense, the respondent shall still be found liable for all such offenses, but shall nonetheless only be meted with appropriate penalty for most serious offense. Section 41. Payment of fines and return of client's money and property. When the penalty imposed is a fine or the respondent is ordered to return the client's money or property, the respondent shall pay or return it within a period not exceeding 3 months from receipt of the decision or resolution. If unpaid or unreturned, the court may cite the respondent in indirect contempt. Section 42. Penalty when the respondent has been previously disbarred. When the respondent has been previously disbarred and is subsequently found guilty of a new charge, the court may impose a fine or order the disbarred lawyer to return the money or property to the client when proper. If the new charge deserves the penalty of a disbarment or suspension from the practice of law, it shall not be imposed, but the penalty shall be recorded in the personal file of the disbarred lawyer in the office of the bar confidant or other office designated for the purpose. In the event that the disbarred lawyer applies for judicial clemency, the penalty so recorded shall be considered in the resolution of the same. Section 43. Immediately executory, furnish copies. The decision or resolution pronouncing the respondent's administrative liability is immediately executory. The copies of the decision or resolution shall be furnished to the office of the bar confidant, the IBP, national office and local chapter to which the respondent belongs, and the office of the court of administrator for circulations to all the courts. Section 44. Confidentiality. Proceedings against lawyers shall be confidential. However, the final order of the Supreme Court shall be published like its decision in other cases. Section 45. Sworn statement after serving of suspension. Upon the expiration of the period of suspension from the practice of law, the lawyer shall file a sworn statement with the Supreme Court through the office of the bar confidant to show that the petitioner during the period of suspension, A, has not appeared before any court, tribunal, or other government agency, whether in respect of current, former, or prospective clients. B. Has not signed or filed any pleadings or other court submission. C. Has duly informed his or her clients, law firm, law school, where the lawyer is teaching, legal clinic, or other legal service organization of which he or she is a member regarding the suspension. And D. Has not otherwise performed any act, directly or indirectly, that amounts to the practice of law. The sworn statement shall state the date of the lawyer's receipt of the order, decision, or resolution imposing the penalty of suspension, as well as a list of the lawyer's engagement affected by the suspension, indicating the relevant court, tribunal, or other government agency, if any. Copies of the sworn statement shall be furnished to the local chapter of the IBP, to the executive judge of the courts, where the suspended lawyer has pending cases handled by him or her, and where he or she has appeared as counsel. Section 46. Resumption of practice of law. The sworn statement shall be considered as proof of the suspended lawyer's compliance with the order of suspension. Such lawyer shall be allowed to resume the practice of law upon the filing of the sworn statement before the Supreme Court. However, any false statement in the sworn statement shall be a ground for a complaint for disbarment. Within 5 days from the filing of the sworn statement, and the Office of the Bar Confidant determines that there is a false statement stated therein, it shall refer the same to the court for its immediate action. Section 47. Reinstatement in the role of attorneys. A lawyer who has been disbarred may file a verified petition for judicial clemency after 5 years from the receipt of the order, decision, or resolution of disbarment. Again, a lawyer who has been disbarred may file a verified petition for judicial clemency after 5 years from the receipt of the order, decision, or resolution of disbarment. Section 48. Petition for judicial clemency. The verified petition for judicial clemency shall allege the following. A. That the verified petition was filed after 5 years from the receipt of the order. Section 48. Petition for judicial clemency. The verified petition for judicial clemency shall allege the following. A. That the verified petition was filed after 5 years from the receipt of the order, decision, or resolution of disbarment. B. That the disbarred lawyer has fully complied with the terms and conditions of all prior disciplinary orders, including orders for restitution. C. That he or she recognized the wrongfulness and seriousness of the misconduct for which he or she was disbarred by showing positive acts evidencing reformation. D. That he or she has reconciled or attempted in good faith to reconcile with the wrong private offended party in the disbarment case, or if the same is not possible, an explanation as to why such attempt or reconciliation could not be made. Where there is no private offended party, the plea for clemency must contain a public apology. And C and E, notwithstanding the conduct for which the disbarred lawyer was disciplined, he or she has the requisite good moral character and competence. Any of the following allegations may also be made in support of the petition. A. That he or she still has productive years that can be put to good use if given a chance. Or B. There is a showing of promise, such as intellectual aptitude, learning of legal document, or contribution to legal scholarship, and the development of the legal system or administrative and other relevant skills as well as the potential for public service. Section 49. Action on the petition for judicial clemency. Prima facie merit. Upon receipt of the petition, the Supreme Court shall conduct a preliminary evaluation and determine if the same has prima facie merit based on the criteria. If the petition has prima facie merit, the Supreme Court shall refer the petition to the Office of the Bar Confidant or any fact-finding body the court so designate for investigation, report, and recommendation. If the petition fails to show any prima facie merit, it shall be denied outright. Section 50. Investigation by the Office of the Bar Confidant or other fact-finding body. The Office of the Bar Confidant or any other fact-finding body designated shall conduct and terminate the investigation and submit to the SC its report and recommendation within 90 calendar days from receipt of the referral. Section 51. Decision on the petition for judicial clemency. Quantum of evidence. The Supreme Court shall decide the petition on the basis of clear and convincing evidence. Section 52. Prohibition against employment of disbarred or suspended lawyer. A lawyer who has been disbarred or suspended shall not be employed or engaged in the practice of law, including the performance of the following. A. Providing legal consultation or advice. B. Appearing on behalf of a client in any hearing or proceeding before any court, tribunal, or other government agency or office. C. Appearing as a representative of a client at a deposition or other discovery matter. D. Negotiating or transacting any legal matter for or on behalf of a client with third parties. E. Receiving, disbursing, or otherwise handling a client's funds. H. Teaching law subjects in any educational institution. Or G. Acting and being commissioned as a notary public. A suspended lawyer shall immediately cease and desist from the practice of law until the suspension is lifted by the Supreme Court. Any client previously represented by a suspended lawyer may engage the services of a new lawyer. The disbarment or suspension of a handling lawyer shall not terminate the lawyer-client engagement between the client and the law firm, unless the client chooses otherwise. Section 53. Costs. All reasonable and necessary expenses incurred in relation to disciplinary and disbarment proceedings are lawful charges for which the parties may be taxed as costs, subject to proof. General provisions. Section 1. Transitory provisions. The CPRA shall be applied to all pending and future cases except to the extent that in the opinion of the Supreme Court, its retroactive application would not be feasible or would work injustice, in which case the procedure under which the cases were filed shall govern. Section 2. Repealing clause. The Code of Professional Responsibility of 1998, Section 20 to 37 of Rule 138, and Rule 139B of the Rules of Court are repealed. The lawyer's oath, as found in Article 138 of the Rules of Court, is amended and superseded. Any resolution, circular, bar matter, or administrative order issued by the principals established in decisions of the Supreme Court inconsistent with the CPRA I deem modified and repealed. Section 3. Effectivity clause. The CPRA shall take effect 15 calendar days after its publication in the Official Gazette or newspaper of general circulation.